On the 30th of May of 2022, the Court of Appeal Criminal Division handed down judgment in the Crown and Collins, the Crown and Lewis and Jaffa, which is reported at 2022, 4 Weeklies, 99. The judgment related to conjoined appeals, which raised important questions in relation to sentencing for misconduct in public office. The background to the first of the two cases was that in the early hours of the morning on the 6th of June of 2020, two sisters, Nicole Smallman and Bibaa Henry, were brutally murdered in a park in northwest London. They'd been at an outdoor party to celebrate Bibaa's birthday. The last of the guests left shortly after midnight, leaving the two sisters together in the park. And when their friends became concerned about their whereabouts and went back to check on them, they found their bodies hidden in a hedgerow. They'd been stabbed to death. In order to preserve the crime scene for forensic examination before the bodies were moved, a number of police cordons were set up. Jamie Lewis and Lewis Jaffa were on duty that night, and they were assigned with other officers to stand guard, preserving the integrity of the scene and ensuring that it was not contaminated. They were stationed on the innermost cordon, out of sight of the bodies of the victims, but the closest to them of all the officers at the scene. They were ordered by the officer in charge to remain at their posts, but what they in fact did was to cross the police cordon, enter the hedgerow area and approach the bodies, where they then proceeded to take photographs of the victims and then to circulate those photographs amongst fellow officers and friends. A man called Daniel Hussein was later convicted of the murders and sentenced to life imprisonment with a minimum term of 35 years. Both Jamie Lewis and Lewis Jaffa were charged with and pleaded guilty to misconduct in public office. They were each sentenced to 2 years, 9 months imprisonment, and their applications for leave to appeal against sentence were referred by the Registrar of Criminal Appeals to the full court. The background to the second of the two cases was that Darren Collins had, since 2002, worked as a civilian employee of the Staffordshire Police, initially as an IT technical support officer, and latterly, from 2015, as a digital forensic specialist whose role was to examine and report upon the content of digital devices seized during police investigations. He was subject to strict terms and conditions governing the confidentiality of information, and his employment contract stipulated that he was only permitted to use police resources and information in connection with his work for the Staffordshire Constabulary. He also received training in data protection and in the lawful handling of police information. However, in January 2019, in the course of an unrelated inquiry, police investigators seized his work computers, and when they were examined, it emerged that over the years he had transferred from police databases to his own personal computers and other electronic devices literally thousands of images taken at the scenes of crimes investigated by Staffordshire Police. They included images of murder victims and of decomposed bodies, and also post-mortem photographs. Darren Collins pleaded guilty to misconduct in public office and was sentenced to 3 years imprisonment. He appealed against sentence with leave of the single judge. In handing down the judgment of the Court of Appeal Criminal Division, the President of the Queen's Bench Division, Dame Victoria Sharp, referred to Attorney General's Reference Number 3 of 2003, Ghazi Ahmed Qasim, Mark Edward Bohannon, and Alan Stephen Butler. Her Ladyship noted that in Bohannon the court had reviewed the authorities and then said as follows, and I quote, "They are illustrative of a number of important principles. First, punishment and deterrence are always important elements in these cases. Not only must police officers be deterred from misconduct, but also the public must see that condign punishment will be visited on police officers who betray the trust reposed in them and who don't live up to the high standards of the police service. Secondly, an incentive, usually money, but it need not be, inevitably increases the seriousness of the offence. Third, misconduct which encourages or permits criminals to behave in the belief that they will be kept informed of areas to avoid in connection with their criminal activities, or of those who might be informing the police, also increases its gravity. And fourth, any misconduct that impacts on police operations moves the offence into a different category of gravity. End of quote. Dame Victoria Sharp then held as follows. Point 1. Save in exceptional circumstances, the gravity of the offence and the high public interest in deterrence means that it will attract a sentence of immediate custody. Point 2. The broad principles set out in the quoted passage are plainly not an exhaustive list of factors relevant to sentencing. There will be other aggravating or mitigating factors in particular cases. But the Bohannon principles are a good starting point for sentencing in misconduct cases. Point 3. In the fourth Bohannon principle, the court recognised the gravity of offending that has an impact on police operations. Misconduct that does have an impact on the investigation and prosecution of crime must be regarded as serious. It's essential that the public should be able to trust the police to play their proper part in ensuring that those who commit crimes are brought to justice. Misconduct that undermines public trust in the process of bringing those guilty of serious offences to justice or prevents innocent people obtaining early exculpation must be punished severely. Point 4. The harm caused by sending images to others was not limited to distribution of images to members of the public who weren't bound by the same duties of confidentiality as police officers. When images were shown or distributed by one police officer to another, that had a corrosive and pernicious effect, putting pressure on colleagues to collude in activity that demeans the police and is hidden from those who have responsibility for the effective investigation of crime. And finally, point 5. For these purposes, there is no material difference between a civilian forensic examiner and a police officer, and the public is entitled to expect the same standard of conduct from both. And so, for all these reasons, the appeal in the case of Collins was dismissed, and the applications for leave to appeal in the cases of Lewis and Jaffa were refused.